Benjamin Doko. There's a second case that is on.
Notice.
NICN/LA/09/2023 between Mr. Johnny Ojega and Access Pension Limited.
May it please this honorable court.
Appearances.
May it please this honorable court. The name is Tolu Alashe Dele Peters.
Can I hear
Respect. Can you hear me, my lord? Can
Go
you hear
ahead.
me, my lord? Yes, the name is Tolu Alashe.
Yes, I can hear you. Yes, I can hear you.
The name is Tolu Alashe Dele Peters.
Okay, I got that.
Or the claimant.
I got that. Is the defense counsel online? Yes.
He has created.
Oh my God.
May it please the court.
Okay.
My name is Otobon Umo for the defendant.
So this is the ruling between Mr. Johnny Ojega and Access Pensions Ltd. This is a ruling of the court on an oral application made by the claimant on the 14th day of January 2026 before this court. The learned defense counsel tendered some documents through its supreme witness, Jennifer Ogunde, Deputy Manager, Legal, Southwest Zone Office of the National Pencon Commission. This had become necessary as the defendant's sole witness had referred to this document. The documents tendered by the supreme witness as follows. 1. Payment and received by Pencom. 2. A summary and expenses incurred in respect of regulatory intervention from August 2011 to December 2023. A letter issued by Pencom dated 8th of December 2011. And 4. A letter issued by Pencom dated 12th of April 2018. These were admitted and marked as subpoenaed DW2, subpoenaed 15 and subpoenaed D15 respectively. On the had tendered the documents. Claimant counsel informed the court that the claimant had issued its own subpoena dated the 9th of October 2025. Claimant counsel applied to cross-examine the subpoena witness. However, this court did not allow it on the ground that the witness had just been served in court and may not need to seek further clarification from her superiors. The matter was then adjourned. On the 14th of January 2026, when this matter came up, the claimant counsel informed this court of his existing subpoena. However, it was opposed by the defendant on the ground that the claimant had closed his case and would require leave of court to reopen his case. The defendant counsel also argued that the defendant merely summoned the subpoenaed witness to tender documents which were already before the court 19 of the Evidence Act. Furthermore, he contended that the purported subpoena issued on the 9th of October by the claimant was captioned, and I quote, subpoena decus tecum. And so, even if the witness was in court, he could not mention that the claimant had closed his case and no leave to reopen same had been obtained. And secondly, that the subpoena witness, the subpoena witness could not be cross-examined. Claimant counsel again informed the court that in response to the subpoena issued by the defendant, the claimant issued its own subpoena filed on the 8th of October. Counsel urged the court to consider the content of the subpoena rather than the labeling. On the issue of leave of court, the claimant counsel argued that the claimant's right to give evidence was hinged on the ongoing proceeding and that it does not have it on record that the defendant had closed its case. Claimant counsel further argued that in the light of the previous proceeding, they were entitled to an adjournment and the defendant was not prejudiced in any manner. However, defense counsel instead they had closed their case. Resolution. The simple issue before this court is to determine whether or not the claimant had cross-examined the supreme witness, and if same will not amount to reopening of his case without leave of court. In the course of trial, parties will and are expected to usually they are sworn on oath in line with the rules of court. They are also strictly called that are commanded to appear before the court to testify or produce a document or to do both. These are witnesses under subpoena. For this ruling, there is need to whichever guise they may appear. In the Nigerian jurisprudence, subpoena summons come in two common forms: subpoena ad testificandum Can you hear me?
Okay, my Lord, my Lord, we can hear you now, but
okay,
at
sorry.
the point we couldn't hear you.
Yes, I was knocked off by the network. Okay. So there is, however, a class of witnesses, although not so strictly called, that are commanded to appear before the court to testify or produce a document or to do both. These are witnesses under subpoena. For this ruling, there is need to ensure clarity as to the variance of subpoenas and applicable practices, whichever guise they may appear. In the Nigerian jurisprudence, subpoena summons come in two common forms: subpoena ad testificandum, which is issued to compel a person to come testify in court, and subpoena decus tecum, which is used to cause a person to produce a document in court. 6 sections 218, 219, and 253 of the Evidence Act. There is a third variant which combines the elements of the two forms above, which is known as subpoena decus tecum ad testificandum. The main issue in this application is as to whether the claimant has the right to cross-examine the supreme witness of the defendant, a staff of PENCOM, summoned by subpoena dated the 29th of September 2029, or anybody at all for the purpose of speaking to the documents already tendered. I'm mindful of the fact that the claimant may not see his intended action as a cross-examination, notwithstanding the claimant's aim is to ask questions bordering on answers or questions given by the defendant's supreme witness for the purpose of discrediting same. This is cross-examination. It does not matter that the claimant has issued a separate subpoena. Back to the main issue, it is important to ascertain the nature of the subpoena dated the 29th of September 2025, issued by the defendant. The heading of the document is clearly written: subpoena decus tecum under Form 39, in line with the practice of this court. The contents of the subpoena clearly lists the documents that the recipient is to produce in court. There is no argument that the subpoena dated the 29th of September 2025 is a subpoena decus tecum. The law regarding this is very clear. On the distinction regarding subpoena, the court held in Ibrahim versus Ogunleye, and I quote, subpoena ad testificandum is a subpoena ordering a witness to appear and give testimony, while subpoena decus tecum is one ordering the witness to appear and bring specific documents or records. See page 510, paragraph D. The law and procedure for a subpoena has not changed. Anyone summoned via subpoena decus tecum is only to produce a document without more. Where a party wishes to cross-examine a subpoena a subpoenaed witness for the purpose of speaking to the documents, then the proper someone is a hello? On the 15th of October 2025, when the witness on subpoena came to court, all she did was to tender. She was neither sworn nor examined in evidence. Specifically speaking, even if a person under a subpoena decus tecum is erroneously sworn, he still cannot be cross-examined. See the case of Tewogbade and Agbabiaka, citation also provided. The words of Dan Laniz Damachi, JCA, in the case of Okon versus DPP, utmost clarity as follows, and I quote, by its very nature, a subpoena decus tecum is a direction by the court for a person to produce documents in court. Quite unlike a subpoena ad testificandum, a person responding to a subpoena decus tecum is not required to appear or give testimony as a witness. Hence, a party called by virtue of a subpoena decus tecum to come and only tender documents need not be sworn. However, if D3 was someone with a subpoena decus tecum, he was only required to produce a document in his possession or under his control, and it does not thereby become a witness and need not become a witness and need not go into the witness box and be sworn and cannot be cross-examined. See on here. In that case, however, although DW1 are testifying on record, oath was applied to them. This in examination. As such, there is in fact no right of cross-examination of DW2 vested in the appellant, and the lower court was right to refuse his application to cross-examine DW2. End of quotation. Furthermore, the claimant labeled subpoena decus tecum in the acknowledged form. However, the content of the subpoena reads as follows, and I quote, you are commanded in the name of the President of the Federal Republic of Nigeria to attend this court on the 15th day of October 2025 at the hour of 9 o'clock in the forenoon, and so from day to day to give evidence in the above named case, Mr. Johnny Ojeaga versus Access Pension. That the above is for the purpose of giving evidence and not to tender a document. This makes it a subpoena ad testificandum just as the claimant had intended. Hence, the court shall treat the mislabeling as a misnomer. Notwithstanding, the claimant cannot summon the defendant's witness for cross-examination or to give any question in relation to the documents already tendered. That right does not exist in law and in practice. It is my finding that the subpoena dated the 9th of October 2025 is defective for the purpose for which it was intended to be used. The purpose for which it was intended to be used. The purpose for which it was intended to be used. The purpose for which it was intended to be used. Notwithstanding, the claimant cannot summon the defendant's witness for cross-examination or to answer any question in relation to the documents already tendered. That right does not exist in law and in practice. It is my finding that the subpoena dated the 9th of October 2025 is defective for the purpose for which it was intended to be used, standing the fact that the subpoena was signed by this court, CCBN versus Interstellar Communications, citation provided. The second issue that arose as a consequence is to determine whether the claimant's action does not amount to reopening his case without leave of the court. On closure of the case, the defendant closed their case on the 16th of July 2025. The claimant concluded evidence and closed his own case on the 22nd of February 2025. See Order 37, Rule 6 of the NICN rules. The defendant is of the view and using a subpoena amounts to reopening his case without leave of court. This court agrees with the defendant. The rules permit a party to reopen his case or call additional witnesses, whichever guise they may appear, but this must be done with leave of court. See Ayan Wale versus and that citation provided. The claimant subpoena is seeking to introduce new evidence via the closure of the case is incompetent. See also 1E versus Omotosho citation provided. However, even then, an application for leave to reopen the case shall be for the purpose of clarifying a point in issue already in evidence. See Order 38, Rule 29 and 31 of the NSCN Procedure Rules 2017. The subpoena of his case. The claimant, having closed his case, cannot be allowed to reopen the case without leave of court. The claimant has no right to cross-examine in this instance except with leave. Accordingly, the subpoena dated the 9th of October 2026 is hereby set aside. This is the ruling of the court.
As the court pleases. We appreciate my Lord for the ruling just delivered. And my Lord-in-law, cost follows event. And my Lord, we shall be asking for costs, being the successful party as far as this application is concerned, my Lord. And we shall be asking for cost of 300,000 naira.
Yes, my lord, we're grateful for the well-considered ruling of the court. My lord, as it relates to the application for court, we would not be conceding to that. The application that was made on the last adjourned date, my lord, as it relates to an adjournment. That was the application that was raised by the claimant's counsel, and not as it relates to opening of case or recalling of a witness or other ways. The defendant has not suffered any prejudice in any manner whatsoever. The principles of court are well spelled out. So it's not just the reading of an application, but the evidence of having suffered a prejudice in any manner. We would not be considering to cost most gratefully.
We will take an adjournment. In the circumstance, we are adjourning so that parties can file their final address, right? Hello?
Yes, my Lord.
Have you left the meeting?
Yes, my Lord.
Give us a date. Okay. First week of May. Mm. 5, 6. 5, 6. 5th of May.
5th of May. My Lord, 5th of May is not convenient.
6th. Look at the 6th.
My Lord, 6th also is not convenient, but we can come back on the 12th of May.
My lord, the first
Or
and the
13th.
second
Is it
week of
claimant?
May first and the second week of May are not convenient, my lord.
Pardon?
Both the first and the second week of May are
The
not
second is not
convenient.
convenient. Okay, good.
Are not country.
Okay, go
Thank
to the
you.
second week of June. Quickly. Second week of June. 10th. 8th, 9th, 10th. No, that week is not good for me. Okay. But we'll be in Abuja. Let's go to the third week. 17th of June. 17th of June.
Convenience, my
17th
lord.
of June. It's convenient, my Lord.
So case adjourned to the 17th day of June 2026 for adoption of final written addresses.
As the court pleases. We are grateful, my Lord.
Let's go to my
Which case is this now? Is this the Benjamin Oko's case? Got it. Benjamin Oko's case.
Shegun, are you doing? Are you the
Yes,
counsel
this
to
was David.
Benjamin Oko?
No. David counsel to David Chibuike Ilonze.
Okay. Is that like this? Yes.
Ilonze.
Is the other counsel online? Is the other counsel online?
Not sure.
Then who is this other person? Ahmed Rajisan Chamber.
No, he's not in this firm. This one is 10 plus.
10 plus is for David Ilonze.
Yes, I'm for the
Templars for
claimant.
David Ulonze. Is Templars for David Ulonze?
No, for Star Sites. For Star Sites. Star Sites Power Utility. That's the defendant. I am for the claimant.
Okay. Are they online? The
You mean the
defendants, are they
parties?
online?
The parties are not online, but the parties have not been appearing in the matter so far. They have not appeared in the matter. It's only counsel that have been appearing.
Yes, it's the counsel there.
Yes, is the counsel here
I am here. I'm counsel for the
for the
claimant.
claimant? Then
Yes,
how
I'm
about the
counsel. So
defendant counsel?
well,
No,
I
the
haven't seen
defendant
them. I believe they were notified.
already the NPO.
No, maybe you should tell me to call them.
Okay, but Thomas, Ibrahim, can you call the defendant? It's already 4 o'clock. We don't have so much time. Leave the meeting. So you want to turn off the
Let me just turn off
the video and the
So, Hello, council.
Yes.
Well, we are adjourning the matter because time has gone and we can't go ahead again. Oh, till tomorrow. Has been adjourned to tomorrow.
What time? Is it online too?
So they should come to court.
Come, no, it's not online. To be physical.
Hello?
Hello?
Yes, I said what time?
Okay, who is Joseph Abukwe?
Okay, that's the counsel.
Who is Joseph Abukwe?
That should be the lawyer on the other side. He's here now. That's him. He's there. That's the defendant's counsel.
You want it virtually?
No, we are ready now. Joseph is here now.
But I'm not
No,
rogue.
we can't do it today.
We just got this information this afternoon. So even if you're doing it today, I'm not rogue. I didn't prepare for court today. So I think tomorrow.
But you can
Tomorrow then.
Wow.
But we don't. I don't mind if it's just the ruling. My Lord will allow us to appear like
So
this.
tomorrow by 3.
Can it be virtual?
It's virtual.
Virtual. Okay, so that works. That's fine.
Okay.
All right, thank you.
3. No, after.
3 virtual.
Yes, 3 virtually.
Okay. Thank you.